Hello doctor. Before I begin, let me introduce myself and my group members. My name is Dashani Shanmugam and my metric number is 269819 along with Maladi Sargunan, metric number 269815, Kumaran Muniandi, metric number 271025, Sharmila Jayasilan 270028 and Kugendran Kumaran 272991. First of all, I want to talk about introduction. In today's world, the computer can perform a wide range of functions. As an example, we use computers to scan groceries at the supermarket, withdraw money from an ATM, pay parking tickets, and so on. In general, a computer is an electronic machine or device that can perform, manipulate, or store information or data based on instruction from software and hardware programs. The use of a computer to achieve criminal goals such as fraud, trafficking in child pornography, and intellectual property, stealing identities, or invading privacy is known as cybercrime. Cybercrime, particularly over the internet, has grown in prominence as computers has become more significant in business, entertainment, and government. Because computers and the internet were widely adopted in the United States early on, the majority of the earliest cybercrime victims and perpetrators were Americans. By the 21st century, however, almost every hamlet on the planet has been impacted by cybercrime in some way. On the case study, my group members and I have discussed and found some offences which was committed by Vida, Mustika and Bella. We used Vida, Mustika and Bella offences as our key point in this assignment.
Hi doctor, my name is Kumaran Muniandi and my metric number is 271025. Before I start discussing about my issue, I would like to apologize if I sneeze or cough because today I'm not feeling really well. And now back to the topic. The issue I'm going to discuss about is the issue in this case, which is Vida and Mystica using unauthorized access to ATM by cloning the bank cards and hacking them to reprogram in order to exploit the weakness in the authentication process to hack the ATM. So, Vida and Mustika can be charged under Computer Crime Act 1997? That is the question. Now, I'm going to talk about the rule or law in this case. Computer Crime Act 1997 under Section 3. The relevant law in this situation is Section 3 bracket 1 provides that a person shall be guilty of an offence if he or she causes a computer to perform any function with intent to secure access to any program or data held in any computer. The access he or she intends to secure is unauthorized. So as we know, in this case, they clone the cards and hack the ATM machine. So both have similar characteristics which we can link to this section. Next, I'm going to talk about the case. The case related to this issue is in To Siwei vs. Cedric John Mount and Honor 2017. This case has been bringing up to High Court Penang and judged by Abdul Wahab JC. There is total of 3 parties, which is the plaintiff was the CEO of Penang Adventist Hospital, or in short form PAH, which appointed on 6 December 2011. The first defendant, which are trustee and president of PAH, and the second defendant was the vice president of medical affairs. The plaintiff contended that the first defendant has been hacked into his private email account while he was overseas. They also obtained spamming emails that were later given out to third party. He lodged a complaint with Windows Line team and later with the law enforcement. The plaintiff has been terminated by the first defender over the emails. The defendant contend that the information within the emails demonstrated professional wrongdoing and should be distributed for review of the plaintiff's position on a public interest note. This information was conveyed both internally and externally from PAG. including at the Board of Trustees meeting to review his termination. Instead, the plaintiff was permitted to resign from his position, but after a formal complaint he was later reinstated. In this case, there is putting a charge under Section 8 of the Computer Crime Act 1997, which is unauthorized access to the data, program, or information excluded the conflicting is proven. In and Section 114 bracket A of Evidence Act 1950 presumes that a person who possesses the theft goods unless the person account for his possession. Thank you. Now I will continue with the case. The defendant has brought up some of their arguments. The arguments will be stated as below. The defendant stated that they did not hack the plaintiff's email account. On the other hand, once the possession of the email, he was under a day of Chief Executive Office to unearth the contest. Invasion of privacy did not recognized by Malaysian law. For the final judgment, the breach of confidence claim could not be sustained. Plaintiff emails were not set as public. The evidence did not support a finding that the defendant had hacked the plaintiff email account. Now I'm going to talk about the application. Computer Crime Act 1997 under Section 3. The application of this law to this case is Vida and Mustika commit an offence if Vida and Mustika deliberately and purposely gain unauthorized access to computer and cause it to execute any function in order to get access to any software or data stored in computer, such as they hacking the ATM and cloning the bank cards. A person who found guilty of an offence under Section 3 faces a fine up to 50,000 or a sentence up to 5 years in jail or both. In conclusion, Vida and Mustika can be charged on Computer Crime Act 1997 under Section 3 bracket 1 for cloning the ATM card and hacking the ATM machine if they were found guilty.
Hi, a very good day to all. My name is Sharmila Anapropo Jesilan, metric number 270028. Now I will be presenting about the issue number 2, which is Vida can be charged under Computer Crime Act 1997 for persuading the ATM to authorize the transaction and bypassing the authentication process for cash withdrawal. The rule or law can be applied in this case is Computer Crime Act 1997 under Section 5 bracket 1. An individual commits an illegal act or crime if he or she performs something that will result in unlawful modification of a computer's content. It made no difference whether an unlawful alteration is permanent or temporary for the purposes of this section. The case related to the issue is between Lee and Dr. Lim and Enos on 2011. The accuser sued the found offender under the actionable thought where the offender occupied the privacy of the accuser through computer misuse and unauthorized authentication. The highlighted issue of this case is punishment need to be given for the offender who invade an individual privacy by misusing the computer. Thus, the offender charged upon Computer Crime Act 1997 for the misuse of computer to invade the victim's privacy. The application, rule or law for this case, Computer Crime Act 1997 under Section 5.1. Vida, who does know that persuading and bypassing the authentication process will cause an unauthorized modification to the ATM machine. So, Vida should be declared as guilty. Vida can be charged a fine not beyond than $10,000, imprisonment not exceed more than 3 years, or can be charged both. The subsequent confiscation. Vida can be fined not beyond than $20,000, charged imprisonment for not exceeding 5 years, or can be charged both. So for the conclusion, Vida can be charged on Computer Crime Act 1997 under Section 5(1) for misusing the authentication process to persuade the ATM machine for cash withdrawal. That's all from me. Thank you.
Hi, my name is Malti Sarugunan. My metric number is 269815. Today I'm going to present about a case study which is about Vida, Mustika and Bella are three computer programmers and they engaged in criminal activities. The issue that I found from this case study is it Vida and Mustika can be charged under Computer Crime Act 1997 for withdrawing money without proper authorization, like attempt to insert few cards in ATM machines. Rule or law. Computer Crime Act 1997 under Section 4. Section 4(1) of CCA provides that a person shall be guilty of an offense under this section if he commits an offense referred in Section 3 with intent to commit an offense involving fraud or dishonesty, or which causes injury as defined in the Penal Code Act 574, or to facilitate the communication of such an offense, whether by himself or by any other person. The similar case that I found is PPV Muhammad Zulkainil Yusuf. Zulkainil, who is 39 years old, was accused of withdrawing Rm 12,150 from a bank account owned by Ismail Mohammad in multiple transactions between 22 January to 14 February 2017. He earlier posed as a bank staff responsible in managing Umrah and pilgrimage package before he managed to devise the victim to hand over his ATM card and password for the payment of the non-existent package. High Court charged Zulkainil under Section 4(1)(a) Computer Crime Act 11 charges, pleaded guilty. Application. Computer Crime Act 1997 under Section 4 deals with the ulterior intent offense. It is an offense if a person with an ulterior intention to withdraw money without proper authorization. Section 4 provides that a person guilty of an offense under this section shall on conviction to be liable to fine not exceeding 150,000 ringgit or to imprisonment for a term not exceeding 10 years to both. Therefore, Vida and Mustika should be declared as guilty and can be charged or exceeding Rm 150,000. In addition, Vida and Mustika also can be imprisoned for a term of not exceeding 10 years or both under Section 4 because attempt to insert few cards in ATM machines. Conclusion. Vida and Mustika can be charged on Computer Crime Act 1997 under Section 4(1) for involving in fraud activities like withdrawing money without proper authorization. Thank you.
Hello sir, my name is Kugendran and my metric number is 2729991, and today I would like to discuss about the management of fraud and issue 4. The issue today I want to discuss about is it Bella can be charged under Computer Crime Act 1997 for appeared to be near the ATM premise. Rule or law. The relevant law in this situation is Computer Crime Act 1997 under Section 7(1) state that any person who aids or abets the commission of or tries to commit an offence under this law act is guilty of that crime and, if convicted, is subject to the penalty specified for the offence. Section 7(2) additionally specifies that any person who commits any act preparatory to or in furtherance of the commission of any crime under this Act will be guilty of that offence and shall be subject to penalty imposed for the offence conviction, provided, however, that any sentence imposed does not exceed one half of the maximum sentence allowed for the offence. The case Kailash Chandra Parekh v. State of Assam 2003, the word atom is defined by the court as an effort to conduct an offence that was not completed owing to certain impediments beyond those control. An effort to commit an offence begins when all preparations are complete and the offender then does anything with the aim of committing the crime, which is a step towards committing the offence. An atom, according to this, is an inchoate crime with purpose and criminal attempt preparations are thorough. The application of the case, applying the legislation to the current base, Bella was knowingly involved in the crime and had knowledge that she was doing was illegal, may cause damage, and that she should be punished under Section 7(1) of the Computer Crime Act 1997. Bella will be found guilty and will face a fine equal to the principal offence plus a sentence of imprisonment equal to one half of the maximum term for the principal offence if convicted. The conclusion of this case will be Bella can be charged on Computer Crime Act 1997 under Section 7(1) for attempting in the crime of manipulate the ATM into allowing the transaction and bypassed the authentication for cash withdrawal. Thank you.
In conclusion, there are 4 offences which we managed to identify in this case. The 4 offences are Vida clones the bank card, Vida manipulate the ATM for unauthorized transaction attempt for fraud by inserting few cards to the ATM machine to withdrawing money without proper authorization, and Bella witnessed the crime scene at ATM premise which happened between Vida and Mustika. For the issue 1, 2 and 3, Vida and Mustika can be charged on Computer Crime Act 1997 under Section 3, Section 4 and Section 5, while for the issue 4, Bella can be charged under Section 7 of Computer Crime Act 1997. That's all from our group. Thank you.